Thanks for joining. We're going to talk today about complaint drafting and discovery drafting, and hopefully that'll make a reasonable video. So if you've been with us in following lessons, and we've talked about intake and our initial review, our document gathering, our investigation of the defendant, and now we're ready to get the party started, so to speak. So we want to file our complaint. A couple of basic rules that we try to follow. First of all, we want to tell a story in a chronological fashion. And, we're used to federal court, so short, plain statements, numbered paragraphs, and we just want to move very methodically through how our clients have been treated by the defendant, what's wrong, and why they have been mistreated and why they should recover, and then what their damages are. The idea being that when you take your statement of facts from your complaint, if you drop that into your motion for summary judgment opposition, that will inevitably come at the end of discovery in a consumer case, you should be able to look at those facts and know that if I've proven those facts with competent evidence, no chance summary judgment is going to be entered against me. And if you don't plead the case with that type of factual, substantive material, you're doing yourself a disservice and you're setting yourself up for problems. Really should look at the jury charges for the claim that you intend to bring and know what elements you have to prove, and you should make sure you plead those, because summary judgment gets granted two ways. One is you don't have evidence of a particular element. Two is they can prove some fact that creates an exception to the elements of your claim or defense, and so you get kicked on something like that. So know what you got to prove, know that you got the facts and evidence to prove it, plead that, and do it as simply and in a straightforward fashion as possible. If you practice in federal court, you're familiar with what we call Twickball, Twombly, and Iqbal, which I like to refer to as a motion to dismiss, a motion for summary judgment sans evidence or without evidence. I mean, basically, Twickball has become a situation where if a judge just doesn't like the way your case sounds, then you may get kicked. So make sure your case reinforces the concept that you are a very serious attorney with a very serious case. You know exactly what you have to prove, and you have the evidence to prove it. Because if you ever end up having to take something like that up on appeal, you want to know that you're dead right, someone else is dead wrong. Because again, our goal is to get paid at the end of these cases to recover for our clients so that they can be taken care of and made whole. It is not to spend 2.5 years of our life working an extreme amount of hours to pursue a case only to lose. So make sure you do a good job with a good chronological statement of facts supported by the evidence you should have already developed, and know that that evidence proves the elements of your claim. For me, I've gone from pleading 10 or 12 counts to looking for the most simple count that includes, compensatory damages, punitive damages, and fee shifting. That's, if you find one of my current cases in Chicago, you may find out that the only claim I have is what we call ICFA unfairness, or unfairness under the Illinois Consumer Fraud and Deceptive Business Practices Act, because it is essentially a negligence standard. Any violation of law that's actionable causes great consumer harm or violates public policy bore you with the minutia of that, but any good consumer case meets that standard, and it gives you a full spectrum of damages. There's no need for any other claim unless you need a federal question claim for diversity jurisdiction purposes. So, or for federal jurisdiction purposes, if you don't have diversity. So once you've got your complaint drafted, you've alleged what you need to know that you can prove your elements, and in theory, you have your evidence in hand for the most part, or else you know right where to go to get it. Then you're going to look at your discovery. Most lawsuits, what do we get? We get a lawsuit. We get an answer or a motion to dismiss, but then we get to the point of having a discovery, parties planning meeting in federal court or discovery conference in state court where you talk about, well, what do you need? This is what I need. And, you start talking about what's got to be done. So your discovery drafting, you always have to take into account, what have you got to get and where is it located? And, one thing that I think all of us can do a better job on, and I will spend some time on this, is talking about, ESI and electronic discovery, and detail some of the fights that we've had over this and lessons learned, that sort of thing. But, at the end of the day, electronic discovery really makes or breaks most cases. And in consumer litigation, we get fought harder over those issues than probably anything else. Nothing worse for, a Wells Fargo type defendant than to have an email from the CEO saying, we know we're screwing people and we just don't care. So they want to keep you away from that type of evidence. They want you to never see internal emails or messages. They don't want you to know the results of any internal investigations. Don't want you to know about their quality assurance review program or their risk review program. And so you end up in a scenario where, you're fighting the devil to get to anything beyond your basic information. But you got to know what you need, and you got to fight that fight, because at the end of the day, in consumer cases, getting the information about, what the defendants knew, when they knew it, and what decisions they make, when they became aware of a problem, and, how they decided to treat the consumers. All those things are hugely relevant to the issues in your case. They're relevant to state of mind. They're relevant to notice and knowledge. And, without that information, you have an inadequate picture of the defendant's behavior. So, we don't always send out written discovery at the beginning of cases. Sometimes we have these meet and confers, and we ask to talk about ESI, and we get experts involved, and we have a huge conference about what discovery's out there, and what types of systems are used, and how is it stored, and what are records retention policies, and what litigation holds, and all these types of things. And then sometimes it just requires going and taking a deposition from someone to get a better grip on what you need to ask and how you need to ask it. We always have that fight, and no matter what we get from initial disclosures, no matter what we get from initial written discovery, at some point in a case, inevitably, we're going to get testimony about some category of documents or investigations or reports we didn't hear anything about until the witness was in front of us. And that always triggers supplemental rounds of, going and fetching additional material. So it's not uncommon to have thousands of pages come into a case, or tens of thousands of pages come into a case, after initial discovery. But we always want to make sure that our initial discovery is targeted and is, specific enough to be related to our subject matter, broad enough to encompass the things that are important to the case. And that is it's a matter of time and effort for the most part. When you have a case that you think is worth 7 figures or 8 figures, spend the time to make sure that the discovery you send is well worth what you're expecting to recover for your client in that case. Don't send some canned boilerplate stuff that looks like it was borrowed from some lawyer 10 years ago, because you've essentially wasted that discovery. It's not going to get you anywhere. It's not going to help you with the case. It's not going to get you what you need. So take the time to do that right. And, you can start building that discovery while you're doing your investigation and drafting your complaint. It's nothing wrong with thinking ahead to the things that you're going to need to ask about and find out about to get to that information. So definitely, start early in that process, make it as specific and targeted as possible, and make sure that you can go in front of a judge and explain exactly why you need it and exactly why it is relevant and important and proportional to your case. So, thank you again for joining me and going through this issue, thinking through how we do these things, talking about it. We're going to talk about what happens when discovery gets answered on the next video. What do we do and how do we do it? So thanks again for joining me, Nick Wooten, Consumer Trial Lawyer Academy. Hope this is useful. Like and share, like and subscribe, whatever it is that YouTube says. And see you again soon, hopefully.